Awesome. And we are live. Thank you for joining us today for our latest fireside chat. I'm Andrew Weiner, head of partnerships at iComply Investor Services. iComply is a global software provider of KYC and AML identity and risk management solutions for financial institutions, capital markets, corporate and professional legal services, and so much more. I'd like to take a moment here before we get started and have our panel introduce themselves, starting with my friend on my right.
Hi, my name is Gene Demira. I'm the Chief Identity Officer for the AML Shop. The AML Shop is a consultancy firm in Canada that provides services globally related to anti-money laundering and financial crime. And in my chief identity experience, I'm bringing in the nexus of digital identification methods and tools and technologies and how those interact with the fight against financial crime globally. And looking forward to the conversation today. This is definitely a hot and ongoing topic, and looking forward to rolling up our sleeves and digging a little deeper.
Yeah, fully agree, Gene. Hi, everyone. So this is Dimitri from Anagram Compliance. This is basically my consultancy advisory firm, where I am helping clients to do the transition and into digital assets or digitalize their own onboarding processes, implement risk categories, risk structures, advise on various technical solutions in order to automate the onboarding process and make the life of a compliance person and the budget a little bit, more useful. And yeah, so far a lot of clients going on. I'm helping a couple of them in with the license application of the FCA, for example, and as well with the BaFin in Germany. So yeah, I'm basically the European market.
I appreciate you both so much for taking the time out of your very busy schedules, especially in this remote world that we're all working in today, to take the time to get on this panel with me. For our viewers tuning in from YouTube, you can ask this panel a question at any time. Just post one in that comment section there. You can also find today's chat on LinkedIn Live and at iComplyIS on Twitter. Today, we will be discussing navigating the complexities of beneficial ownership and analyzing today's modern challenges of performing UBO due diligence. Now, for those unfamiliar with the subject, UBO is an acronym for Ultimate Beneficial Owner. An ultimate beneficial owner can be defined as the natural person or persons who gains from, owns, or controls a legal entity. Financial criminals have become adept at using multi-layered and multi-jurisdictional legal structures riddled with shell companies as a way of masking who their UBOs are in efforts to launder illicit funds. These layers of complexity definitely muddies the water and obscures the identity of the real beneficial owners of these entities, whose activities are costing governments around the world approximately 2.6 trillion American dollars a year, as reported recently by the United Nations. It's clear that bad actors are able to exploit much of this current system, but they still make up just a small fraction of the market. With that in mind, my first question to the panel, and I'll start with Dimitri. How do you spot potential risk in the proverbial haystack of a complex structure to separate bad actors and the legal entity?
So the first thing is actually to take a step back and to understand what is the structure about, what is the economic activity. The most reasonable thing is to look at an org chart, an organigram, something that tells you an indication of who does what and for what reason. For example, on a fund-related structure, private equity, this is just by nature, it's way more complex because the volume of funds is just way higher. And also there's a lot of things play a role in terms of segregation of liabilities, segregation of assets. You don't want to have the real estate investments being commingled with the high risk, startup venture fund, because if one fails, it will drag the other one with it. So in order to analyze a UBO structure, especially when it is multi-jurisdictional, you have to look at the economic reason first. In my opinion, something that is just out of nowhere, that doesn't make sense, that should be a red flag. One thing that I have always looked at is the history of companies. That usually helps to get a rough indication. Because when you see a company is hopping from one offshore jurisdiction to the other within 1 year, and even in Europe, if you have an Estonian entity, let's say, and then they close the company and moves on to Lithuania after 1 year, then the next year they move to another country. So they basically avoid reporting, they avoid to create an actual track record because they could be found, right? That is always a high risk. And then obviously the natural things as background research, adverse media research, maybe something is on the internet, maybe they've left some trails that they didn't know that exist. And a lot of the things, they're actually public, registries, they're public. You can do a lot of things on UBO without actually having to pay a single cent. It's just that you have to know where to look for, and you have to understand the economic rationale in order to track this.
Excellent points. And Gene, same question to you. I know that you're currently based out of Canada with the AML shop. What are some of those indicators that you look for to help you separate bad actors and legitimate entities?
Yeah, definitely, by all means. And even before the AML shop, my past background was reporting to the global CAMLO for a very large insurance company with a presence in Canada, US, and a dozen countries in Asia. So we definitely had seen a lot of these different types of exposures and the like. There is some variability between different jurisdictions and criminals, and as well as very advanced tax preparers know this. And one of the pieces that's an interesting piece to try to unravel some of those nuances that is starting to take aim at this, that is opening a few organizations' eyes, is the common reporting standard and taxation declarations that are required for legal entities. However, it's debated about whether if that goes far enough, as it really it places the most pressure on passive non-financial entities, purely investment vehicle ones. So if there's active revenues coming in, they're not collecting as much information, they're not doing that resolution. And then also the traceability, when you go across those different entities, just as Dimitri picked up on for sure, is the challenge, is that they're playing the lack of interoperability as being a big challenge, and playing on that strength. And they're also playing on the fragmentation on the registrar's offices, especially when you have federated countries like Canada and US and many other jurisdictions where the registration for the businesses are regionalized and not on a national level. So you have a lot of inconsistencies in practices of how much information is collected, what type of information, and the integrity of the information is all obscured. And then there's identity theft on top of that information that can be abused even further. So these layered on with nominees make that haystack a challenge. And I think right now we're not even getting to the needles in the haystack. We're just trying to find the haystacks themselves. Really, at the end of the day, that alone is a challenge. Is it hay, or is it straw, or is it just a big pile of weeds? We got to figure that part out on its own before we actually get in towards any needles.
Absolutely, I totally agree with you, Gene. And you mentioned a very good point, and that is actually tax transparency in Europe, and I guess that in the US something similar is going to come up as well, if not already. The fourth and fifth AML directive have basically introduced that tax evasion and aggravated tax fraud is a predicate offense of money laundering. So that is something new. Compliance officers in financial institutions that are regulated, they're asking themselves the question, how am I supposed to track this? What are the risk factors? This is not an easy task. And the question is as well, looking at the tax structure makes a lot of sense, because a lot of the pieces that go up when there is one UBO, somebody will have to benefit from it, right? Now the thing is also, it poses real world difficulties because we live in a global financial system. So what do you have if you have, for example, a Cayman Islands resident, and that person doesn't have a tax number? What do you do? It's perfectly legal in Cayman Islands not to have a tax number because there's just jurisdictionally, there is no tax. So are you requesting something from the UBO that he cannot provide? Will he then be put on some kind of high risk list or whatsoever? Will there be a suspicious activity report behind that? These are all very, very tricky questions. And this is real life questions. So yeah, it's,
exactly. And I think just to compound that as well. So, which is an interesting nuance. So Canada just added tax evasion as what it's called a hybrid offense, which makes it a predicate offense in the last 5 years or 5 to 10 years. And in the United States, it has been an offense of a felony stage or predicate offense for over 100 years. So, and as we watch Hollywood and wonderful movies and everything else, and have the story of Al Capone and how they took him down for tax evasion and the like, and the money laundering that went with that, I completely agree that this is a philosophical change. I think that was quite powerful. But the FATF position of adjusting to influencing countries to move towards tax evasion, I think is quite material, and I think it is critical and important, and it goes towards improved resolution for the individual's identity as well. And that's where I will often circle back to identity. But I think that's a big part. If you are going to talk about finding financial crime and tracing the source of funds and source of wealth to make sure it's not financial crime, step one is you need to know who you're dealing with, and is it reasonable of who this person that you're dealing with is giving you legitimate proceeds or not. And so if you don't know who you're dealing with, how could you ever get to that? And taxation information is quite relevant for that, because then it gives you traceability towards vital stats. Are you dealing with a synthetic identity and synthetic person underneath the screen? And then also further to what you had touched on, there's different identifiers with different countries. So somebody easily could be a tax resident for multiple jurisdictions. If Andrew sadly lost his favorite uncle in Ireland that gave him a full chain of Irish pubs that he now inherits, and he becomes a tax resident of both Ireland and Canada, the other complexity into the mix that comes in is what's the Irish tax rules and laws and capabilities, and will the information and funding exchange of Andrew taking his basically his income from Ireland and bringing it to Canada where he lives, is that a trip and an indicator of a potential tax evasion that Andrew is doing either to Ireland or to Canada? And then is he unfairly being reported to the government simply because he's taking money out from his legitimate means, because it's tied to a cash-intensive business and trips on multiple indicators of international exposure? And is there a privacy consideration? Is there a human rights consideration into all of that? So we're starting to jump into a lot of complexity, which is the area that criminals love, because they could ride in like an open highway with no speed limits right down the middle of that complexity and benefit from it. So that's where, thankfully, there's a lot of great tools that are coming into the tool chest that can help us work through that complexity. But I think the interoperability elements is a key part that we should touch on, and the identity resolution on how that goes into tax, I think, is going to be continue to be critical.
And as you guys were going through this topic here, one of the questions that came in from the audience, and I'm going to post it here, and we'll start with Gene on this one. What is the difference between the concept of beneficial ownership and ultimate beneficial ownership with respect to this type of screening and identity investigations?
So I think that the piece really at the end of the day is getting to the underlying individuals. Once you pass through the different legal entities, so it's direct versus indirect is the way I often term it. Direct ownership is whereby that individual directly owns Corporation ABC, but indirect ownership could be where they own enough of Corporation ABC through other legal entities that they have control or ownership of. So one corporation's owned by another one, owned by another, different stacking, either partially or completely, and or through nominees and power of attorneys and other tools, they could have control over the assets of that corporation. So they're the ones really calling the shots in behind that entity. So the ultimate piece is really getting through, making sure it's precise, that you're not just asking the customer who are the immediate owners of this entity, but getting through those indirect pieces, covering in those other nuances of control of both like power of attorney models and third parties, or other entities into the mix. So Dimitri,
Yeah,
anything else
absolutely.
to add to that, or?
No, that was very, very well explained. Very, really well done. It's just what I wanted to say is, it sounds like an easy concept. Who owns it? It's like a really easy sentence, but the practicalities of this is a freaking nightmare. And you would have no idea what people come up with in terms of corporate structuring, in terms of just simple shares, stock structuring. You can have a differentiation between preferential rights. So, for example, a family, I don't know, let's say typical German company is a car manufacturer. They don't care that much about money as they care about of control. So they tend to separate control from equity. And they're happy to get investors in, and other people participating on the growth of the company, and they can just, I don't know, create a new factory where they can build new cars, modernize their equipment and whatsoever. But what they very much care about is who actually controls, who's calling the shots, and who's the one that is responsible for the strategic outlook of the company. That is the very, very important piece. And now we're talking about only equities. What about convertibles? Like when you have a bond that can be converted to a share on a specific percentage rate. What are you having when you speak about several listings of the same company in various exchanges in other jurisdictions? So, for example, you have dual listings in South Africa, for example, or you have a good example, Carlos Slim Helou, America Movil, is one of the richest persons in the world. If you look only at the Mexican stock exchange where America Movil is listed, he will not be a UBO. Simply not, because he doesn't care about the equity. He has actually a dual listing, which is also in the United States, and through American depository receipts, which is a different financial instrument. But if you convert that to shares, and if you calculate the total amount of the shares, he is going to be a UBO. But if you just look at one exchange, he's not going to be a UBO. So it is a very, very tricky thing. And you already just identifying that a company can have several listings with different requirements, with different voting shares. The reality of this is very complex. And what do you have who's the beneficial owner if you have a trust? A trust doesn't have shares. What do you do if you have a fund structure where you have a limited partner where the capital is and the general partner? So what do? The one has money, the other has control. So who's the UBO? Both of them basically are. If there's anybody that has 25% or more, both of them are. But I just wanted to point out that the reality of all these things is very much complex. And I hope that nobody who's laundering money is watching this.
Well, I think that the grand challenge is that those that are laundering money already have read up on this and hired their own experts separate, and the challenges are quite ingrained in the institutions and into the mix. And I think even further to the resolution items that you're touching on, the other nuance that we got to look at is even what name resolutions. Most of these registries, even the ones that do have beneficial ownership, have very sparse identity resolution markers. And the traditional identity resolution markers that we could think of are name. Even my name that you're seeing on the screen there, Gene DeMira. Well, who is this Gene DeMira? Is my name really Gene? My full legal name isn't Gene. It's Eugenio. And it's quite often this DeMira may be spelt with a space between the I and the M. And then date of birth is another identity resolution. Well, there's entire countries and regions whereby date of birth isn't even captured. It's only year of birth that's captured and honored. And the names themselves, as they get married, they change, or as other life events happen, they change their names, and that's normal in that cultural space. There's entire cultures and regions where AKAs are quite prominent, that they have a legal name, but they're known as something else, and everybody knows, and they completely live by a different name without even any court or other validation pieces to it. And these are normal, reasonable practices. So resolution is not only tricky, but it's a significant challenge of integrity. So even when there's a regulatory push that they say financial institutions must get this information, they must verify this information with their clients. If they're lucky, they can do a compare to the registrars. If there's no assurance level and confidence in the record that's at the registrar, or what's being presented to you, then how can you do that traceability? And typically it's the common commerce and people that are law-abiding citizens that are caught with this added burden. And the criminals have the ability to sneak through, regretfully. So.
Now, you both raised some points here that lead directly into some of these audience questions I've gotten here. So back to Dimitri's point around the metrics of who is the UBO. One of the questions from our live Twitter here is, what specific metrics are being used to determine who qualifies? Where should you start before you decide this is the person I'm going to look at?
I think a reasonable way to look at it is to use a risk-based approach. So it depends. It's the question. It's the typical is the answer. I mean, it's the typical lawyer's answer, and that's, it's unfortunately the nature of the beast. So normally, as per law, there is a 25% plus one share, or more than 25% threshold. Now the thing is, it can be equity, it can be control in terms of voting rights, in terms of other means. Now, the thing is that what happens if you have a higher risk scenario? So in the reality, a lot of companies have gone down the road to say, okay, if we have a high risk case, we have to apply enhanced due diligence. So in order to prove to the regulator that we have done not only our homework, but we have actually really done it like properly, is they lower the threshold to 10%. There have been a couple of conversations here and there to generally agree to have a UBO being defined as 10% or more. The thing is that in the reality, this is gonna be extremely difficult because already the 25% threshold is operationally very challenging. In order to have it down to 10% and identify this, we would really have to connect IT related systems. We have to actually trust the registries. And honestly, a lot of the jobs and a lot of the workload of a compliance person or any AML investigator can be alleviated if you would just be able to have free and open commercial registries where you can actually find the data directly from the registries themselves. Now, the point with that is how valid and how much is the data that is on the registry verified. In the UK right now, the Companies House, they have done, in my opinion, a very, very brave step and very good step. It's absolutely required. They said that they're going to enforce checks on anything that is uploaded on the Companies House registry. So that means, for taking the example of Gene, you cannot create an account with Gene Demira and another account, like another company, as Eugene Demira. So you would have a duplication check, basically. And also the passports, the documents, and everything, it's being properly investigated and properly checked. So, but things like this is not the standard all over Europe. Some of the registries are doing a great job, and they do this, and others they don't. So it's just about getting a collaboration in touch, and also just connecting different databases of registries through an API, through any type of technical means, so that compliance people can actually access the data. It doesn't have to be all publicly available, because sometimes you have UBO data, it's sensitive. Like I have had a case where a client said, well, I don't want to have my address listed publicly for everyone to see that I own 25% or more. And that's a perfectly reasonable argumentation, because why would you have to disclose to anyone that you live in a huge villa and you own that percent? Like, it's not necessary, but it's necessary for another person that is trying to enforce, not enforce, but just follow the law, and just saying, okay, if there is a lawful requirement, I have to do that. Well, I'm gonna do that. Um, that is nothing to do with public or not. You should also bear in mind the privacy of the people, because these people, no matter how big they are individuals, and they have a right for privacy. And that's the thing.
And you know what? I find that interesting, and I love it when the conversation of privacy comes about. And this is where I get to be a little bit contentious into the mix, and I like to challenge people too, because quite often privacy is misunderstood, in my presumption, to being secrecy, and people have a right to secrecy. That is not the case. By privacy by design and privacy in the human rights standpoint, privacy is truly about an individual or party to have control of the information about themselves. And philosophically, that is not the same thing. It may be perceived by some as the same, but it's not. If I'm agreeing to enter into a business relationship where Andrew is giving me one of his many pubs that he's just earned and owned in Ireland, and he's going to give me Friday nights, every time I come to his pub, a free pint in exchange for doing this great session with him, which I will graciously accept, then I'm entering into a business relationship with Andrew. And if in order to do that, Andrew needs to validate identity resolution, that he knows who he's entering a contract with, being me. And as a part of that resolution, also because I'm going into his pub, that I am above the age of 18. From a business relationship to comply with the laws and rules of his country, he needs those data elements. So even after our relationship ceases, let's say if that only lasted for a year, he then has records retention requirements that he needs to retain those records for his tax authority or other legal purposes from a liability and insurance standpoint, and he needs to retain those records for 10 years. Where is my privacy or secrecy that my information is still on file with Andrew? It stays with Andrew. He has to keep it, and he has full rights to, and that's reasonable. So the right to be forgotten, remember, always has a caveat of also control. It's a right that I have to give control of my information to that other party. Yes, I may be forgotten if I never entered a business relationship. If there's no record retention requirements, of course I have the right to be forgotten. And that's much more on knocking on doors on marketing aspects. But the other elements, there is that strong balance. So if you're entering a business relationship where you have property and information in custody with another party, that's where proceeds of crime and protection of society comes in. So the beneficial ownership registry has one other nuance that I'll give that may be considered contentious. And that is exchanging one T word for another. To me, philosophically, the ultimate goal that should be in the FATF principles, that is there to a certain extent, but the ultimate goal that organizations and globally we should look towards is not transparency in the public domain. It is traceability in the public domain. And there, it should be Andrew and his name with his unique identifiers that are strongly attached to his identity resolution performed by a trusted custodian of some sort that should be on public registries. So I wouldn't necessarily know where Andrew lives, because where the addresses that are put on public registries could be a suite number that looks like an apartment building when it's really a PO box or a file number within a law office. So what is the integrity and benefit of that? It's minimal at best. And again,
Totally.
it is an intrusion on the individuals that are honoring the system in good faith. It is not necessarily a benefit for others. And although some jurisdictions may have very low kidnapping rates and identity theft rates related to those capabilities, to me, the overarching public disclosure of name, address, date of birth, and other identifiers should be limited to trusted parties in a traceable fashion where that information is needed for the purposes of reconciliation of identifiers. But ultimately, in the long-term goal, I'm hoping that we can move towards using less irrelevant pieces of information and more greater integrity of information that is traceable down to foundational ID to a higher level of assurance in the identity space.
Yeah,
so
I agree.
those are some potentially contentious, but I think those are things that could happen in the next 2 years. Sorry, Dimitri.
No, I mean, Gene, it's not necessarily contentious. It's just it's reasonable. In my opinion, it's just absolutely reasonable. The thing is, I've had one client from Brazil, for example, when I was working at Deutsche Bank. They were like, "We're not going to send you anything," and we were wondering, how is this possible? But, it is a very big conglomerate, and they produce cement, and it's all family owned. And I was like, okay, I asked my manager at the time, I was like, can I call them? Which is an unusual thing to do. But I was like, okay, I really want this to push forward because a loan was depending on this. And he's like, yeah, okay, go ahead. So I called them. And the sister, who was also doing the day-to-day operations, was very, very honest with me. And I totally appreciate that until this day, because she said, it's not like we don't want to tell you. Absolutely no problem. But you're asking us to send us the originals in a letter into on the other side of the world. Do you know what is going to happen in Brazil when the post guy is coming in and he sees an envelope with a huge freaking documents in there? The first thing he's going to do is he's going to ask who's going to pay me more to see what it is in the letter. For that reason, we do not trust the post system. We have no interest in sending anything to you through the official post way. And as you don't give us another choice, we're not going to do this. And I was like, okay, good. That is honesty. Appreciate it. We're going to send one Deutsche Bank employee directly to in front of your house. He's going to pick it up himself. He's going to ID himself. So you are sure that your data is staying with us. And he was like, she was like, yes, okay, perfectly fine. In the same week, the case was closed. But these are things that the law doesn't really think about. And I mean, it has to kind of give some guidance, of course, because it's the law. But also it's really difficult sometimes in enforcing it and just applying it. And you mentioned the case of the nonsense of UBO registration data. I agree with that as well. I learned in Germany there is a thing which is called a fictional UBO. Now, what the hell is a fictional UBO? Either you are a UBO or you're not, right? You own the thing or you don't. It's a very simple binary option. Well, fictional UBO is basically, okay, I don't want my registration data to be displayed publicly, or that anyone is just able to track me down. So you know what? I'm going to hire some law firm that's going to hold my identification or my data on trust, and they are going to be the one that is considered to be the UBO. This is the way how the industry is going, it seems. Not everywhere, and not in every case, but I agree to your point to saying that the people who are righteous, the people who want good and just follow the law, are the ones that basically are then, not really protected by it in a way, because their information is floating around. You don't know who's accessing it. You don't know what they do with it. And same thing with fake IDs on the dark web. It's a very similar thing. And information is gold right now. Information is honey. I mean, it's like why is Google so valuable? Because they have the information, not because they they do such a great job or whatever.
You
It's
know
not
what?
about money, it's about information.
To tell you the truth, let's. Do you mind if we tackle into that? And I think that there is a good analogy there, Andrew, that that will tie back to UBO, if you'll permit me. I'll challenge
Please.
one piece of what you just touched on, Dimitri, and that is information is gold. Information is what has value. And what I'm going to tackle there is I'm going to contest that it's not information. Not today, it may be to a certain extent, but the true opportunity that we all have, and any financial institution or any organization that holds either information custodianship and identity or property custodianship, which is every financial institution, but it's really every business at the end of the day. It's everybody that has those two. But to me, it's not the information, it's the relationships. What makes Google, Facebook, Netflix, all of these other players extremely valuable, every organization on all the exchanges, is its relationships. That is what has the power. And the relationships, it's also the tie-in of the integrity to those relationships. What is that relationship? Can you vouch for that relationship? Do you give roles and rights to perform certain functions to that relationship? That is going to expand much further. And that is what really at the end of the day, all any legal entity is in its most philosophical form. Sorry, Andrew, I didn't think you expected a philosophy class in this one. But any legal entity, what is it? All it is multiple persons and their roles and rights to come to consensus and create a legal person under the law. That's what a legal entity is. But each person has a relationship with that legal entity and to each other vis-a-vis that legal entity. So it's all about the relationships, the roles and rights, and the core integrity of each individual person. Now, how do you build identity? And how do you build confirmation of who someone is? Well, if I take out my passport, then that is the foundational identity from the government to me, saying the government's vouching that this is Gene DiMera. But if I take out my bank card or my credit card, that's my bank vouching, saying that they've performed KYC and this is Gene DiMera. If I log into this web platform, iComply is vouching that they think that this is Gene DiMera, that has typed his name Gene DiMera in there in a manner of trust, and iComply is somewhat indirectly vouching that as far as they're well aware from reasonable practices that this is Gene DiMera. They're all vouching for me in different levels of degrees of sensitivity. From a legal entity standpoint, usually it's a lawyer or an accountant or other party that's pulling these identities together, vouching for them, putting them on file with the government, and the government's trusting whoever that filer is and all of these other parties that have varying degrees of identity resolution to that mix in order to establish that corporation under the law and recognize it. But then just once those paperwork signed, it doesn't mean it's doing anything. It's then the relationships that those parties that have relationships with the legal entity then take that and give it property and give it services through financial institutions. So it's all about the relationships is where the value lies. And
but relationships is the same thing as information as well. I mean, the information about the relationships is,
yes and no, it doesn't have to be.
Everything is information.
It doesn't have to be, though. Like if we got rid of knowledge-based authentication, if we completely got rid of knowledge-based authentication where you ask, what is your name, address, telephone number, what is your mother's maiden name, what street did you grow up on, and we purely went to a combination of biometrics as well as physicality of what you have of tokens, whether it be with your cell phone with the digital key or other forms of digital keys, and together with localization, and we got rid of knowledge-based authentication, the value of information to corrupt and take your identity would be dramatically diminished. The value of the information is not as relevant because now your traceability of the relationships remain, but how you get there changes. So that's the contentious philosophical point. So getting to UBO, it's all about the traceability to who we're dealing with. Who are we dealing with at the end of the day? What roles and rights they have? Are they hiding behind another person? So if in order to get rid of the nominees and the fictional owners that you mentioned, Dimitri, we need laws to change to say that a legal entity's ownership transaction will not be in effect based on evidentiary acts until it is on file with the government. That could have some material change.
Now, one point from within the philosophy here that the audience is curious about is we're talking about the beneficial ownership and the roles and the rights. And so what is the difference per se between percent of ownership versus percent of control?
Mm-hmm.
And Dimitri, I'll start with you on that.
It's 25%. I mean, the percentage of ownership is you own 25% of the money that the whole company generates and gives up to the head, basically, if it's like a multi-operational company. In terms of voting rights, the assumption is that on a shareholder meeting, 25% is the massive amount, or the stake that has an influence to say no. Basically, that's the deciding factor. This is considered as sufficient to basically jeopardize when someone else is saying yes, someone else is saying no, and then you have the 25% that makes the difference. Then this is the one where you are actually in power. It can also be factually, it can also be 0.0001%. It can also be only one single share, because I have seen the structures, for example, that the voting rights are also completely distributed. They are equally, everyone has 25%, so technically everyone is UBO, but there is one person that is more UBO than everyone else, and that person has one single voting right share that allows the person to have a veto. So if anybody else 100% agrees, but except this one person's vote is going to count. So that's the little difference, I would say.
And Gene, you're just muted there.
Thanks. I would complement that in that saying that there's a lot of different types of class structures of shares that are out there in many countries, and that adds a lot of complexity, whereby someone can convert in Class B or Class C shares into Class A shares. And they have different rights and obligations that they could trigger different elements there to go into away from the corporate structure and go into the trust space. There's the concept of protectors. Where a protector has the right to fire the trustee if they don't like what the trustee is doing. Well, that's an aspect of control, and in a lot of jurisdictions, protectors need to be screened and validated just as well and detected into that mix, and others don't have that. Sometimes if you're dealing with a testamentary trust issued from a will, there could be different clauses within the will that give indirect control to other so-called equivalent to protectors and other pieces that could add some confusion and challenges into that space. And then there's the conflict of privacy, like we just talked about earlier today, about how I'm entering into this great agreement with Andrew, and I'm looking forward to those pints, Andrew. But then let's say if I say that that's also going to be extended into my estate, and then I pass away, and those free beers now go to my beneficiary. Like Dimitri's my beneficiary in there. He didn't even know he was my beneficiary, but now he is the ultimate beneficiary and potentially controller of this testamentary trust that he didn't even know that he was in line for. And he has a legal agreement with you. He never agreed to the release of that personal information. But for you to honor that agreement to meet your AML rules, you need to get that information. So how do you collect it? How do you get it? He never even entered into the contract in the first place, but he got it by virtue of me dying. So then tracing that down, and then the financial institutions in the middle of that. So there's obviously lots of great complexity into the mix, but you know what? It makes our jobs exciting. It makes them interesting. They're forever dynamic, and see how we could
totally agree.
See how we could start tackling one piece at a time. And
I totally agree. I think UBO, sorry to interrupt, but
yeah,
I
yeah.
think really UBO structure and following it, like you feel sometimes a bit like Inspector Gadget, Miss Marples or whatsoever, like a small detective, and you're like, "Ma, does it make sense? How's the calculation? Da, 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 da." And that is one of the most interesting pieces of the job, I must say.
Yeah.
And that kind of leads into the next question here. So we're talking about data privacy a lot in this call, how to distinguish between control and ownership. With AML-D5 and the rules and requirements today for UBO identification, how and has technology played a role in organizations embracing this need to do the monitoring after this first check of the UBO, and of course assessing the impact of change in their status to risk? And that's an open question. Either of you can tackle that one.
There's some great tools out there. Dimitri, do you want to kick it off? I've recently done some work in some of this space, but
Oh, I'm curious to hear that.
okay, great.
Go ahead.
So there's some great tools that have come into the tool chest. That one of the biggest challenges, for example, that especially for organizations that dealt with small trusts as well as mom and pop corporations, as I call it, that hold the holdings of a family business and the like. One of the challenges you often have is people move. Their siblings move. Their children and the benefactors move internationally. And one of the simple examples and technology tools that are out there is the digital capture and verification of foundational identification tools. So there's a lot of photo ID capture tools in the marketplace that are very powerful, and they can read the using your mobile device. They could read the NFC chip of any passport that has a mobile chip on there, and download the high resolution photo, and then do the liveness validation across their face and do that matching. So the identification of that UBO, when you end up having that small mom and pop and you're trying to set up the account and say, well, look, I want to know who this UBO is, but they're also a trustee, so I need to collect their ID. Well, the technology can really do a dramatic shift in order to help in the identification of those parties. There's an organization I'm actively working with that's called the DIAC, the Digital ID and Authentication Council Canada. It's very similar to NIST, the NIST standards group in the US and a lot of the identity groups in Europe and elsewhere. And they came up with a free directory that's on its website that does a comparison of a number of different factors of these identification capture tools. So that helps, at least you know who you're dealing with at the other end. Obviously, matching who you're dealing with then, is this really the Andrew I need to deal with that owns those Irish pubs? Or is there a different person of the exact same name that's trying to infiltrate and pretend to be that Andrew in order to try to steal those pubs or its assets? Or is the next question into the mix? And that's where there's some great technology platforms that are using a variety of different tools out there. You're often hearing about artificial intelligence tools that's doing a lot of investigation work internationally. There's obviously some fantastic data sets from a lot of the leading market players out there that also provide some great intelligence. And then it's the combination of both of those to there's so much data and information there to use then machine learning, which is really, I call it advanced filtration, that just basically sorts through the data at the end of the day. And then artificial intelligence is advanced filtration with a whole bunch of more variable multiple buckets in tubes. So it's just that combination there too. So I think there's some great tools that to help filter out the vastness of information, especially when you're dealing with a lot of common names and common capabilities. But I think those are some of the nuances into the mix. The last piece I'm looking forward where technology can go, that I've seen some things that are perpetrating that they think that they can do this well, is trade-based money laundering detection for legal entities, and taking a look at the information that's provided by legal entities in the markets they're in, and then tracing that back into really good open data and open data systems and open data capabilities, using tools like open banking that can go into their bank account and validate, is this reasonable of the information I'm getting about this business? So a lot of those other tools, I think, are going to be really, really powerful into the mix, such as open banking to validate. So if somebody says that my chain of hairdressing salons is making $500,000 a year, well, let's go into their open banking account and see where the revenue flows and back and forth are to see whether if that's legitimate. So I think those things are going to be very powerful. And that may also help validate a UBO as well, because if all of a sudden payments are going out from that business to particular individuals, that may imply that somebody else really has control of that organization through trade-based money laundering means. So I think those are going to be nuances that are not expectations today, but for high net worth clients on a risk-based approach, high value clients, they may be some added tools into the tool chest in the future, into the mix.
Yeah, absolutely. And then one of the next steps could also be everybody's talking about blockchain and Bitcoin and Ethereum, and it's also amazing. It is amazing. Not everything must be used though blockchain doesn't have to be used on all cases, because it has its limitations as well. But the thing is that the traceability and the creation of a shared Excel sheet, basically, that is verifying that the data is correct, allows you as well to trace through forensics, through data analysis, a lot of the funds, and identify the hops in between. What is the history of the fund? Because this is basically the one that is covering source of funds, source of wealth. Does it make sense that a hairdresser just cashed in 200,000? I don't know. Well, we could basically analyze where she received those funds from. And that would be a very interesting thing. And this is just the first level. We are only right now working on the creation of the backbone of everything. But then the backbone is just step number one. It's just like finance in 1960s or 70s. And there will be a lot of levels to build the whole house. On top of it, the addresses are going to be more more connected to actual real people, to actual real institutions, where okay, they do the AML checks in equivalence to yourself, and then you can just ask them, if there is a suspicion or something like this, you could point the regulator or the FIU, the Financial Investigation Unit, you can point them into a direction and make their jobs easier to trace back. Because the simple truth is that the systems that we're using now, and there is no regulation that is going to change this, the tools that we're using right now are ineffective and absolutely horrendously costly. Like, it doesn't make any sense. When you look at the market, it's still like 90% is being laundered in USD still. It's not cryptocurrency. I mean, of course, cryptocurrencies are being used for criminal offenses, for various other things. But it's just the better tool in order to allow a transparent financial market in the future. We'll see with CBDCs.
Yeah, I completely agree. I think my personal view on virtual assets, though, is the challenge is the wallets and the identity to the wallets. So the traceability is fantastic. It's all we could wish for. The challenge is really like one of the stats I heard before was as little as 6% of global wallets have any form of KYC, and even the KYC that's been performed was wholly inadequate, because it was utilizing in many respects, not all, like there are some that are using state-of-the-art tools, but remember, a lot of our laws are written based on paper. They're written based on physicality, and they haven't modernized, and they're just starting to modernize, utilizing the tools today of when we identify someone, we perform the resolution, we validate to trusted sources, and need to have those interactions with those trusted sources. And then we also have the physicality of liveness and all these other pieces that need to come into fruition. And then we need to maintain that authenticity for that same person using device fingerprinting or other tools in the digital realm, or use our memories and other elements in the physical realm. So these pieces are an ongoing challenge. And I agree with you that we have some great tools now. We have great intent right now to try following things, and we are moving in the right direction. So I think that to leave on a more positive note, I'd say that the interest and the excitement is there. But I think I saw one comment in the chat of, are certain jurisdictions considered riskier than others? Sorry, Andrew, if I'm stealing your thunder there, but it leads well into this point is, well, there's certain jurisdictions that they it sounds like they have this nailed. The FATF had a beneficial ownership consultative forum earlier this week, and Spain had demonstrated a fantastic new program, and where I believe they're using a heavy use of notaries in order to add the personal touch, but also increase the identity resolution and the integrity of their system. And I think that's fantastic. I think those are the directions we need to go. But will that be perfect? None of these systems will be perfect, because there's always going to be the human factor that can be corrupted in some way or another. But at the same time, does it need to be perfect? No, we're looking for a risk-based approach. We're not looking for perfection. But we need to get better. And everyone acknowledges that I talk to, and regulators and companies alike. But it needs to be in that risk-based approach, because also if we put it too much of a burden on any one party or any one process, it's not risk-based, and the economy will suffer. And we have enough challenges in our lives today with the economy and everything, and other factors that everyone knows about, that we can't afford that. So we got to keep that risk-based approach in that right balancing act. Some countries are doing better than others. Some countries have a better infrastructure and overarching payment system that they don't have to weigh into others as much. So you can't take a look at UBO in isolation. You need to take a look at the totality into the mix in order to see reasonableness into that as well.
And gentlemen, we have reached time. I wanted to thank you both for carrying a phenomenal panel. These were excellent insights and very lively conversation between you two. I'm so happy that I was able to host you guys today. Before we break, I'd love to give you a chance to just let the audience know, starting with Gene, where can they find you online if they would like to talk to you again after this panel or follow up?
Oh, that's fantastic. And thanks again for iComply for the great opportunity, and Dimitri, my panel co-host as well. Andrew, I wish you the best with those Irish pubs. I hope that comes to fruition someday for you. And I hope that you have me over for that pint. The amlshop.ca is our website, and it has all of our contact information. Please feel free to link up with me on LinkedIn as well. There are very few Demiras with that last name in the world, so you could easily find me as Gene Demira, or Eugenio Demira is my full legal name. And or if you even Google, like I think if you still Google digital identification and AML, my white paper or other articles on the topic may come up, as I've done a bit of work in that space. But thank you again, iComply, and my co-panelist. If there's any interest in continuing conversation, please reach out. Thank you.
Same here, of course. Thanks a lot, Andrew and Matthew and Gene, of course, for this great panel. Was a lot of fun and lively. You could find anything when you want to contact myself. Just look me up on LinkedIn on Dimitri Gede, or just drop a message to Anagram Compliance. The homepage is anagramcompliance.com. Yeah, and if there's anything I can help, absolutely just drop me a message. Thank you so much for the great evening, guys.
Excellent. Thank you so much. And you can find us at www.icomplyis.com, as well as on Twitter at iComplyIS, LinkedIn at iComply Investor Services, Inc. And tune in on December 17th for our next fireside chat, how compliance changed in 2020. We'll be looking at the year in review, the AML D5, et cetera, everything that went live and impacted the world of compliance. And again, thank you to our co-host today. I hope you guys have a wonderful afternoon, and I look forward to seeing you all again next month.